At BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. You are welcome to Heritage TV and also BWF Solicitors platform with the Legal Hour show. Today, we're going to talk about eligible persons who can apply to the EU settlement scheme by 30th June 2021. Today is the first day of May, so we've got another 30, is it? May, end of May, June. So we've got 2 months, to have this sorted out. So we thought it was appropriate for us to talk about EU settlement scheme, which ends by 30th June 2021. This program is sponsored by BWF Solicitors, your #1 law firm in the whole of UK and in Ghana. And it's also sponsored by Victon Estates, your #1 property management company in the UK. Today I've got with me our learned solicitor, lawyer Eunice Achampong, Mrs., who will be taking us through this topic. Let me welcome Eunice. Hello, Eunice.
Hello, Vicky. How are you?
Good. And you?
I'm doing well by God's grace. I hope your week was good as well. That's good.
Can you hear me, Laurie?
Okay, now I can hear you better.
Yes, so let's go straight to the topic. Eligible, persons who can apply to the EU settlement scheme by 30th June 2021. What prompted you to, bring this topic up for us to have a discussion about it? And also,
Okay.
who is a member of the relevant entities under the immigration policy? So these 2 questions.
Okay.
Tell us we feel we should speak to, talk about it. Today being the 1st of May, and also, tell us who is a family member of the relevant EA citizen under the immigration policy.
Okay, let me first of all say hello and happy new month to all our viewers and those that are listening to us wherever they are in the world. I know that as May draws near, very quickly we'll be entering into the middle of the year, and then very soon the year will be over. So happy new month to everybody out there. In terms of our topic for today, when we say eligible persons, because a lot of people do keep asking who can still make the application because they know that the time limit is drawing near. It is not that the EU settlement scheme is coming to an end, but it is to say that there is a deadline for those who are in the UK and who are family members of EU nationals or who may have retained their rights or who may have derivative rights to remain in the UK will have to make these applications by 30th June 2021. So as we've been saying over the past few months and over the past year or two, the EU is part and parcel of what has been what we call the free movement. So whilst the UK was part of the EU, we had certain treaties that kept the UK bound to keep EU nationals coming to and fro from the UK and to other EU countries. But as we voted to come out of the EU, now we are out of the EU, which was last year, January. We obviously made sure that we were now out of the EU. And therefore, the UK government had to put certain laws in place to protect those EU nationals who are already in the UK so that at least they will have some security in terms of their legal status. And that is why the UK government came up with the EU withdrawal agreement. And of course, that included making sure that those EU nationals and their family members will still be, will still have some legal status whilst they remain in the UK. And that is why they came up with the EU settlement scheme, where they can apply to the scheme and be granted pre-settled status, which is limited leave to remain, or settled status, which is indefinite leave to remain in the UK. And so the deadline for EU nationals to have come into the UK to be able to be eligible for this scheme was the 31st of December 2020, last year. And so after that date, the UK government have said if you are an EU national and you want to enter into the UK with any other family members, then you have to apply to the points-based system as a skilled worker, as a student, and so on and so forth. So this is applicable to any EU national or their family member or any person who retained their rights or has derivative rights to remain in the UK as of the 31st of December 2020. So if you were living or residing in the UK before the 31st of December, then this is applicable to you because this is where most people would want to know and be sure that they can apply to the EU settlement scheme. And of course, if you were here before and you still want to bring over your family members, you still can do so as of now. So you can still bring over your family members who are direct family members of yours. And so if we are talking about direct family members, as of our immigration rules, you will see that we have Appendix EU, and we also have Appendix EU family permit for those who want to bring over family members to join them in the UK. And so in terms of joining family members, you would see that the definitions, which is in Annex 1 of our Appendix EU and Appendix EU family permit, would refer you to people who may be a spouse or a durable partner before the specified date, which is 31st December 2020, or children of the EU national or his spouse, or the parent of the EU national or his spouse, or it could be that the grandchild of that EU national or their spouse. And then you could also say that in this definition, an adopted child who has been formally adopted and recognized under our UK laws. So if you are looking at the spectrum of, should I say, people who can apply to this EU settlement scheme, those are the people that can apply to the EU settlement scheme. So you have if you have a direct link or a direct relationship with that family member, then of course you can make that application for that family member to also join you. So it's important that those who are already here, living here in the UK, understand that they are to apply to the scheme, whether or not they have residence card for 5 years under their previous EEA regulations 2016, or whether they have permanent residence card, which some people who are family members of EU nationals may have, or those who may have retained their rights will also have. And then you also have people who are EU nationals themselves who may have a blue card, which is called a registration certificate. And if you don't even have that as an EU national, you would still have to apply to the EU settlement scheme. And I know that most people who would have heard about this would have made the necessary steps to obviously apply to the scheme. And obviously the government have also made sure that they have informed employers and local authorities and other community services that may come into contact with EU nationals or their family members, or those who may have the biometric card that says 5 years residence card or permanent residence on there. So it's useful to know that the government is trying to also do something to make sure that people are aware that they are to apply to the scheme by the 30th of June 2021. And we don't want people to lose out, because then it means that if you haven't applied to the scheme, it means you do not have any legal status to remain in the UK, and we don't want a situation like that. Of course, they have said that there might be cases where people may have reasonable reasons, which they may say, for instance, they didn't know they had to apply for maybe a child or somebody who was in care or somebody who may be a vulnerable person. And so therefore, if you fall into that category and you haven't made the application by 30th of June, you also have these, should I say, reasonable excuses to give. But let's not go there. Let's try and make sure that we are making the application in time so that we don't fall into these categories, and then we have to further provide evidence why it was not done in time. So yes, to keep it short and simple, this is for EU nationals or their family members who have already resided or are residing in the UK and were in the UK before the 31st of December 2020.
How about those who have retained their rights or have derivative rights residents?
Okay, so with those that have retained their rights, so maybe it could be that there was a person who was married to an EA national and they've divorced, and so they've lived with that EA national for at least a year before they divorced, and the marriage lasted for at least 3 years. And so if somebody like that is in such a situation, they should be able to provide evidence that before the divorce or when the divorce proceedings started, the EU national was working or had permanent residence in the UK, and they who are an non-EU national have continued to work in the UK as of then. So if that is somebody like that, then of course you too have to apply to the EU settlement scheme. And then you have those that may have lost an EU national family member, and so they should obviously have to show that before they died, at least they worked here for a year. And if they can provide evidence to show that they were a qualified person, so they were working here in the UK for at least a year, then of course they too can apply under the EU settlement scheme for pre-settled status or settled status. And then you have people who may have had a relationship with an EU national. So let's say their husband was here and then all of a sudden abandoned the family and it no longer resides here in the UK. Those people also have retained their rights, and therefore, as long as they can show that the EU national was living here and obviously working here in the UK at the time, then of course they too can apply to the scheme. And then you have those that have derivative rights. So they may be primary carers of an EU national child or a British citizen. And when we talk about primary carers, those are people that care for that child, and the child must be in education. So if for any reason that parent is not here or that primary carer is not here, then unfortunately it would mean that the child will be unable to continue living in the UK because they need the care and support of that primary carer to continue living in the UK. So it's important that that primary carer has the derivative rights to continue to care for that child. And previously in our EU regulation 2016, the route was not leading on to settlement. So they didn't have that route to say that because you have residence as a primary care of a child who is EU national or a British citizen, you can then apply for indefinite leave or you can then apply for settlement. But with the EU settlement scheme, they too can apply to have indefinite leave to remain if they can prove that they have looked after this British child or looked after this EU national child for a continuous period of 5 years or more. And so it's important that those who also have derivative rights, residence card, to also apply to this scheme. And I know there have been instances where, for instance, a child who is a dependent of the primary carer would also apply to the scheme. And then if that dependent is over the age of 18, they have said to that child, unfortunately, because you are now an adult, you can no longer apply to the scheme because you are now over the age of 18. And sometimes this is because of the fact that in our British laws, any person who is 18 and over is a person who is seen to be an adult, and so you are no longer a child, and therefore that person is categorized as somebody who can not be applicable, or somebody who's not eligible to apply to that route because you are now an adult or you are now somebody who they would term as no longer being a dependent. So it puts those children also in such a precarious situation. But if you look at our immigration rules as well, it allows children who are in those categories to also apply for leave to remain as, how do I call it, as individuals, because they also have a private life, or they have private life here in the UK. So these are all different categories, but at least we have the benefit of people who have derivative rights applying to the scheme and also having to apply for indefinite leave to remain once they have lived here continuously for that 5-year period. Yeah.
Well, it's managing this. You can see from I'm going to take BWF solicitors myself and would intercept those questions and answer them. Lawyer Eunice, wow, I've got Buki who is just sent in her question. She says, my children are Italian and so am I. I arrived in the UK in 2019 and I've been granted pre-settled status. Whilst in Italy, I formally adopted my sister's son, who joined us from Ghana. I would like my children to join me in the UK, including my nephew. How do I go about it?
Okay. So in this question, it seems that Buki wants to bring over her children, and then she wants to bring over her sister's child, who she has informally adopted as well. Of course, if Buki was residing here before the 31st of December 2020, and as she has rightly put it, she's applied to the EU settlement scheme, then of course she can apply for the children as well to join her from Italy. And because the children were not residing here before the 31st of December 2020, they will have to apply for a family permit. So that will be for 6 months. And so once they've been granted family permits to join her here in the UK, she can apply for the children to also have pre-settled status, or whichever status she has. So as she has said, she came in 2019, so she would definitely be granted limited leave to remain or pre-settled status to continue to remain in the UK. And the fantastic thing is that you don't even have to show that you were working. You just have to show that you were residing in the UK, unlike our previous EU regulations where you have to show that you were a qualified person, either that you were working or you were self-employed or you were a student with comprehensive sickness insurance or you were a self-sufficient person. All of that is not there. So you just have to show that you were residing in the UK, which is fantastic. And then you have her child that was informally adopted. So when you look, sorry.
Yeah, go on.
Yes. So when you look at our Appendix EU or Appendix EU family permit, when it you look at the definitions, because there's definitions to a lot of the keywords that they have, so that it makes it easier for you to understand what it is they are talking about. And so you have an adopted child. So when they're talking about an adopted child, they want to see that the child has been adopted through the relevant process and therefore meets all of the adoption requirements. So if anybody has ever adopted a child before in the UK, you would know that you will have to go through a process of informing your local authority, and then they assess you. And then if the child is outside of the UK, then the eligibility requirements will be sent to whichever department is outside of the UK to obviously then assess you and then assess whether the child will be better placed with you as a parent. And then obviously you need the court order to be able to grant you that adoption order, and so on and so forth. So obviously if it is a recognized adoption by the UK or under our UK adoption laws, then of course you can say that that child is also a child of the family, even though they are adopted. But in this case, you have a child who is informally adopted. So there isn't any paperwork, there isn't anything to show that they have gone through the adoption process or the relevant adoption process. And so it means that that child becomes a child who is also known as an extended family member. And so in 2019, we had this case where SM Algeria, where the visa section was taken all the way up to the Court of Justice. In the European Court of Justice, you have a lot of cases where different appellants would take different member states, which in this example was the UK, to the Court of Justice. And these were Muslim parents who had informally adopted a child, and they had supported and looked after this child for a long period of time. And therefore, it became important that the UK revisit a lot of their regulations, because even though this child was not formally adopted, this child was considered to be an extended family member within the circumstances, of course, because there was no formal adoption, but the parents were able to show that this child had depended on them for a long period of time. And therefore, this child was an extended family member to the EA national and his wife, which obviously we would see. And so, of course, because of this case law, it became apparent that even family members who are extended family members of the EA national could apply, and those who were extended family members of the spouse could also apply. But then, because the Appendix EU of our immigration rules does not make specific, should I say, definition to that extended family member, it means that most people who would be applying for an adopted child would have to now have had something sort of like a relevant document, because the only reference that our immigration rules makes to somebody who may be classified as an extended family member is a dependent relative. So it says that a dependent relative is somebody who is related to the EA national or the spouse, but then also can show that there has been some form of dependency on them, either financially or socially. And then, of course, if there hasn't been that dependency, but they can show that they have been a member of that EA national's household, or they were living with the EA national previously, and they continue to live with the EA national, then of course they can also make that application. But then they should have a relevant document, which means that they should have an EA family permit, or they should have a residence card, or they should have some permanent residence to be able to show that they were a dependent relative. So in this case, if that adopted child from Italy, who was informally adopted, can show that they have continued to reside with the EA national and the spouse previously in Italy, and are continuing to reside with them here, then of course they can make that application. But if they haven't had any documentation granted to them, such as an EA family permit or some form of residence card previously, then it becomes difficult to now apply for them now, because unfortunately our EA Appendix EU in our immigration rules does not allow extended family members to apply currently, unless they can show that they were a dependent relative who previously were granted an EA family permit to come and join their EA family member, or they now have some form of residence card. So it makes it quite tricky for those people who may be seen as extended family members, or may have informally adopted somebody as should I say, a child when they were very young, whereas somebody who was formally adopted will have the same rights as a child, somebody who was informally adopted will be seen as an extended family member. So in her case, it makes it quite difficult unless the child was previously with her and she can show that the child previously may have been granted some sort of family permit to join her when she was coming in 2019. And then, of course, if she thinks that she cannot prove that, then it means that the child will have to show that they can meet other requirements outside of our Appendix EU to be able to come and reside in the UK. So, like I was saying, as of the 1st of January 2021, they have said anybody who wants to apply to come and reside in the UK will have to apply to the points-based system. And that would mean that they would have to either apply to come here as a skilled worker or a seasonal worker or a student. So obviously there are routes available, but they would also have to look at whether they will be eligible to apply to those other routes. Yeah, so it's one of those should I say complex ones.
Okay, this last question is coming from Alanti. Quickly, he says, I do have children after 30. If I do have children after 30 to 2021, can I still apply under the EU settlement scheme if we have pre-settled settled status?
Yes. So as I was saying, the EU settlement scheme is not coming to an end on the 30th of June 2021. It's still going to be available. So can you imagine that somebody has been granted pre-settled status, which is limited leave to remain, and then by the 30th of June, the scheme ends? Then it means how they're going to apply for settlement, how they're going to apply for indefinite leave to remain in the UK or the rest of it. So you have all these categories of people who may be granted limited leave to remain or pre-settled status, and you have people who would still want to apply to the scheme. And so, for instance, there are those that are, should I say, British nationals who have gone to live outside of the UK and will be coming to join their family back in the UK for the purposes of maybe the fact that they had to go and work outside and now they want to come back and live in the UK. And so the non-EA family members, or should I say the non-British family members, would be coming back with this family member who is a British national. And those people can also apply to the EU settlement scheme because as of the case of Surinder Singh, if you're a British national and you go and work outside of the UK in any of the EU national countries and you return back to your country of origin, as long as you can show that you had your center of life in another EU country with your family members and you resided there for a period of time because that is where your life was at the moment, then of course you can apply to the EU settlement scheme. And they have up until 2022 to make that application. So they are one of the ones where, of course, they have the liberty to still apply to the scheme after the 30th of June 2021. And so in this person's case, where they are saying that they have a child after that date, yes, if you have applied to the EU settlement scheme and you have been granted pre-settled status or settled status, and you have a child born after the 30th of June 2021, of course, you can still apply for that child to be granted pre-settled status or settled status after the 30th of June 2021. Because, of course, the government cannot stop child rearing or childbirth as of that time. And so any person who gives birth or any person who wants to apply for even their family members to join them will still have the, should I say, right, or they'll still have that opportunity to still apply for the family member. And so it is not the end of the scheme. It is just to let you know that if you are here and you haven't applied to the scheme by the 30th of June 2021, then you wouldn't have an illegal status. You would literally, your immigration status would be precarious. So you wouldn't have a right to say that you are an EA national and therefore you can reside in the UK. You have to have some legal status, which is either limited leave to remain or indefinite leave to remain, to continue to reside in the UK, as EU law no longer would apply in such a situation. And so this is called the grace period, because previously EU nationals had the right and now they no longer have the right. And so they are making sure that as much as possible they come under our British immigration law, and that they have that limited leave to remain or indefinite leave to remain, so that they can continue to work and reside in the UK. So yes, of course, the scheme will still be open for family members to apply once the date of the 30th of June has gone past. So sorry, I couldn't hear what you were saying.
Now you can hear me.
Okay, yes, now I can.
My apologies. Okay, so in the absence of any further questions, I'd like you to quickly, give us your last words, and also give your contact details. Anyone watching us who would like to come and see you regarding this EU settlement scheme.
Okay, so as we've just been talking, of course, there are so many people who are still ignorant of the fact that there is an EU settlement scheme, and therefore they haven't probably even made any attempts to apply to the scheme. And so, as many people as possible who may be watching this should share this and make people aware that they are to apply to the EU settlement scheme by the 30th of June 2021. So, if anybody has any further queries or wants to know more about applying for themselves or their family members, they can call us or they can contact us. We are situated in London. So, as you rightly said, I am a solicitor at BWF Solicitors, and our address is the 4th floor of Anna House, 214 to 218 Tottenham High Road, London, N15 4NP. And so we are usually open from Monday to Friday, 9:30 to the 6 p.m. every Monday to Friday. And our office contact number is 0208 493 7340. So 0208 493 7340. And my contact number out of office hours is 075 35 81 3910. So 075 35 81 3910. And so of course, I wish everybody a nice bank holiday here in the UK, and hopefully next week we will have another topic to share and discuss with you.
I also want to thank your team, BWF Solicitors, for always being there for us, coming our way every Saturday the Legal Hour show to educate us. We thank you so much for your continuous support. I will entreat each and every one of you watching us. If you have any immigration, queries, look no further. Contact BWF solicitors. I would like to take this opportunity to wish everybody a happy bank holiday. And on that note, with Lawyer Eunice, we'll just give you a lovely goodbye wave and hope to see you same time next Saturday. Take care. Bye-bye.
BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.